Can you hear me now? Mic's on. Everything's on. Okay. We'll go ahead and call Fed and State to order. Wednesday, February 16th. First thing on the agenda, we have a bill introduction. Senator Cluse.
Thank you, Mr. Chairman, and it is RS 3173, and it's just concerning prohibiting motorcycle profiling.
Do we have any questions? Any objections? The bill's introduced. I believe you got some guests you want to, and then we'll go back to bill introductions. Go ahead, Mr. Cluse.
Yes, thank you, Mr. Chairman. Today I have a couple of guests in the back pages, and they're from Topeka. Carla from Topeka High. She's standing back there. And Noah from Faith Temple.
Glad to have you.
Welcome them. Yeah.
Thank you. Any more bill introductions? Do we have any in the audience? Not seeing any. We'll move on to our agenda today. Okay, Senate Bill 404. We'll go ahead and open the hearing. Jason, you want to give us an overview?
Thank you, Mr. Chairman, members of the committee. Senate Bill 404, some of the members may recognize this is a bill to authorize a vote on the placement of electronic gaming machines, which otherwise known as slot machines, in Cedric County. That's the first major policy of Senate Bill 404. With that also comes some additional language because of concerns have been raised about potential litigation involving existing casino management contracts down in that gaming zone. And so you also see Section 1 of the bill has language in there requiring notice of intent to enter into a racetrack gaming facility management contract, and if there is, and then provides stipulations for when a lawsuit challenging that action or the authorization for a vote in Sedgwick County under the bill may be filed, what the damages may be under that, and then ultimately, if there's final order of the court, that privilege fees are due to the casino manager for that gaming zone. Then there's provisions for the racetrack gaming facility manager to pay those privilege fees to the state for payment to the casino manager up front, and then to recoup repayment of that reimbursement for that through a portion of the revenues from the slot machines that are operated by that racetrack gaming facility manager over the next some time period to pay back that privilege fee cost. In conjunction with that amendment, there's also an amendment to clearly define that similar gaming facilities under the definition of a lottery gaming facility does not include a racetrack gaming facility. And then there are also amendments to clarify the number of racetrack gaming facilities that may be operated in the state, and to reorganize the distribution of the revenues from those slot machines at racetrack facilities. There is a chart in the memo on Senate Bill 404 showing you what the current percentage distribution is for those slot machine revenues versus what is proposed. And I'm sorry, the chart is mislabeled. It should say Senate Bill 404 in your memo under the current bill. The amendment to authorize the vote in Sedgwick County is in KSA 74-8743. This can either be submitted to the voters by the Board of County Commissioners or upon a petition signed by at least 5,000 voters. And the election would be held within 150 days after adoption of a resolution to submit the question to the voters. There are also provisions to streamline, since certain counties have already passed that vote, and Wyandotte and Crawford, that they would not be required to do so. The remaining provisions of Senate Bill 404 deal with the Kansas Paramutual Racing Act. There are a couple of sections at the beginning of the bill requiring the official breed registering agencies for horses and greyhounds to make recommendations to KRGC on programs to benefit economic development in rural Kansas. And then there's a creation of a Kansas Horse Council Fund to develop, promote, and represent the equine industry in Kansas. Finally, Section 4 authorizes, under the Paramutual Racing Act, that the racetrack facilities could operate one or more historical horse race machines. These are defined in the bill. These machines, as I understand them, once the patron has selected a wager, then a random historic horse race would be selected by the machine. The odds for that horse race would be presented to the patron so they could finalize their wager on it, but no other details as to the outcome or the location of where that horse race actually was run would be revealed to the patron until after the finalization of the wager. Once the wager has been finalized, then the machine would display a portion of or the finish of the race and reveal the identity of the race, and of course the results of that, which would then determine whether or not the patron won on their wager or not. There are similar concerns raised about the authorization of such machines leading to litigation, similar to the concerns regarding the vote on slot machines in Cedric County. So you will see Section 5 of the bill provides the same litigation stipulations on such claims as in Section 1 of the bill. Finally, there are a number of amendments under the Paramutual Racing Act statutes to conform to some of these policy changes in terms of requiring KRGC to review and approve these historical horse race machines and adopt regulations for their operation. There are provisions to reduce the Fair Association application license fees from $500 to $50 and $100 to $25 respectively, and allow a simulcasting license to be issued without the requirement of live racing. I will point out for the committees, point out their attention, in the back, approximately 10 pages of the bill, there are some provisions that show as being stricken in the Paramutual Racing statutes. Those are unintentional strikes and do not actually conform with the overall policy of Senate Bill 404. So if the committee does move forward with this bill, the revisor's office just requests to offer up a technical balloon amendment to reinsert that unintentionally stricken language in that portion of the bill. This will go into effect on July 1st of this year if enacted, and I'd be happy to stand for any questions.
Questions, Senator Longmine?
Thank you, Mr. Chairman. Jason, could you walk me through again one more time the repayment process if these are determined to breach the privilege fee contracts?
Sure. If there is a determination by a final court order that privilege fees are to be repaid to the casino manager, then the racetrack gaming facility manager who's entering into the contract that triggered the litigation would make a payment in the amount of those privilege fees plus the interest as calculated to the state. The state would then make the required court-ordered payment to the casino manager. The state would then set up a repayment receipts fund in which a portion of the slot machine revenues that the state receives from that racetrack operation would then be paid back to the racetrack gaming facility manager as a reimbursement for the upfront payment of the privilege fee repayment.
In other words, the privilege fee breach would be paid up front by the casino manager, racetrack gaming facility manager, and then out of the state's share of the revenue generated by that, we would then have to pay back those entire privilege fees?
We would, yes, the state would reimburse the racetrack facility manager for that upfront payment.
At no more than 50% of our share?
That's correct.
On a per year basis? Okay. Follow up?
Yeah, go ahead.
Is this only in one gaming zone, or is this availability statewide?
Considering that there already were votes that were taken and approved in Wyandotte and Crawford, this vote authorization really is only applicable with respect to Sedgwick County and that gaming zone, because that's where the vote did not pass back in 2007, 2008, whenever that occurred.
The other 3 gaming zones, they could operate these if this bill passes.
There is no racetrack facility. I don't think the Dodge City gaming zone has a facility, and it's authorized to do a racetrack gaming. This would only be applicable in Wyandotte, Crawford, and Sedgwick. And as I said, Wyandotte and Crawford have already authorized it.
And then my final question is, I know in a number of states these have been determined as slot machines, so who would make that determination whether they are or aren't in the state of Kansas?
I'm sorry, what are slot machines?
A lot of states have determined that these are slot machines.
The historical horse race machines?
Yes.
Well, the bill
Make that
defines,
determination in Kansas.
well, the state statute would define them as not being electronic gaming machines and sets out the parameters for how the machines would work. There could potentially be litigation challenging that the actual operation of the machines is an electronic gaming machine and therefore in violation of the Expanded Lottery Act casino management contracts. But that would be then litigated through the courts.
Okay, Senator Hildebrand.
Thank you, Mr. Chairman. Jason, thank you for the bill explanation. Just a couple of quick questions. Has Sedgwick County had a vote on this before?
They did have a vote back after initial passage of the Expanded Lottery Act, and that vote failed.
Okay. And when is the contract, is it 2032?
Yes, that's when the contracts are set to expire.
And then my last question is, just skimming through the bill, it also looks like some of the fees or the percentages are decreased. Is that accurate?
There is a redistribution of the slot machine revenue for these racetrack gaming facilities. If you look at the chart on page, I believe it's 3 of the memo, is a comparison of what is current law, which was what was enacted back in 2007, versus what is being proposed under the bill. And the redistribution more aligns it with what the percentage distribution is for the casino management contracts, with the state receiving 22% of the revenues from those slot machines.
Thank you.
Senator Fascadeau.
Thank you very much, Mr. Chairman. Just 2 quick questions for Jason. And first, I have to say hello to my county commissioner, Meissner, in the audience. Good to see you. So in Wichita, the vote failed in Cedric County. However, in my district, it passed. There was 51% in my district in Cedric County that voted in support of the Greyhound Park. So my 2 questions are, so if this bill were to pass with the measure in it allowing a revote in Cedric County, that would just give the county commissioners the option to put it on the ballot, but it would have to pass before the Wichita Greyhound Park reopened. That's one question. The other question is, just for clarification for those out there, this would not allow Greyhound dog racing. Is that correct?
To answer your first question, the bill only allows the opportunity for a vote in Sedgwick County. So the Board of County Commissioners on their own initiative, or if they're presented with a legal petition to place the question on the ballot, would place the question on the ballot for the vote. To answer your second question, this bill is not intended to affect Greyhound racing whatsoever in the state of Kansas. And so if Wichita Greyhound Park were to reopen after the passage of a new vote authorizing slot machines, that park could run live Greyhound racing. I will point out, this brings me to a point, the bill does make amendments so that live Greyhound racing would not be required at the park in order to operate slot machines at the park. It would not. It could occur, but it would not be required.
Okay, other questions or comments? Senator Peterson.
Thank you, Mr. Chair. What does the current casinos pay in the problem gaming fund? What percentage?
I thought it was 2%, but I can double check.
Thank you.
We can get that for you, so. Andrew, you can check into that. Any further questions? Not seeing any, thank you. Let's go ahead and start with our first proponent. We'll open the hearing on 404, Scott Beeler.
Good morning, Mr. Chairman and Vice Chairman, Ranking Member, and the members of the committee. Again, I am Scott Beeler. I practice law with the Lathrop GPM law firm, and honored to be here today representing Ruffin Properties as a proponent of this bill. I'd like to say there's an old adage in the law that the body who creates law is the only body qualified to define its own intent. As a number of you who have sat in this room before know, every year it seems that when a version of a bill like this is brought, opposition likes to talk about ambiguities and how they are impacted in some manner by those ambiguities. Once again, if the proponents of this bill believe that there are no ambiguities, that gaming and who can game in Kansas and in what manner is well stated in the existing law. We just know that others come up and bang the rostrum loudly to say that is not so, and the state is at risk, and you could be involved in a $1 billion lawsuit. I want everyone to hear me loud and clearly when I say I don't believe there is any support for those types of allegations. I haven't believed that in any of the years I have stood here. But I understand that as elected legislators of the state, you owe it to your constituents to look into those matters and to be sure. And so this bill, while somewhat complicated, is drawn to address all of those concerns. It is to allow this body who created these laws to state and qualify your intent. That's what the point of this is. And again, you're the only party who can do that. We've heard in other hearings such as this about the Attorney General and his stance. Well, that's old news now. But even he, in that old news, in that opinion, said over and over, it is not his ability or his job to talk about your intent. So let's just say, and questions have already been asked. And Jason, thank you so much for your comments today and your work on this bill. But there is no question but that from the beginning of KELA, go back to 2007, there are 4 authorized lottery gaming facilities in Kansas. They are in specific geographic areas. So forget the fact that they're built and operating and making many, many millions of dollars. Let's go back to then. What was authorized? 1 in Northeast Kansas, 1 in Southeast Kansas, 1 in South Central, and 1 in the Southwest. That's the Dodge City one that was referenced. At the same time, that many years ago, 3 racetrack facilities were authorized. And the law says each one of those will be in the same geographic location as the lottery gaming facility, except the Southwest, where there won't be one. That's why it's 3 instead of 4. What else do we know? We know all 4 of those casinos are sure operating, and we know that they come here every year to oppose this legislation. We know that. We also know that none of the 3 racetrack facilities are operating. Why? Because they are not economically feasible under the current legislation. Again, done some 15 years ago, going back to KELA, or 12 years ago with the last amendments. We know that there is a completely upside down tax comparison, slot machine to slot machine, EGM to EGM. I've said before, the very same machine sitting side by side, the same machine is taxed in a casino at 22% and in a racetrack at 40%. Racetracks have all the other expenses associated with a racetrack. It's no wonder they're not in operation. It is a lost economic opportunity, a revenue-generating opportunity for the state of Kansas every day that those are closed. So let's get back to what this bill does. It doesn't change anything I just went through. It doesn't expand gaming in any way, shape, or form. It simply acknowledges that there can be the four casinos and 3 tracks. That's what it says. It says that you can vote to have EGMs in your track facility. Once again, the Attorney General did not say that Wichita cannot have a second vote after 15 years. What he said was that the legislature would have to allow that. This bill does that. You don't say put a racetrack in Wichita. You say let the voters vote if you make this clarification of intent. Again, it's been my position that that vote's been allowed all along. General Schmidt and I don't see eye to eye on that, but as he has recognized, if the legislature clarifies it, so be it. That's what this does. And as everyone has said, it still just means if you put this in, they still have to bring it to a vote, and that vote has to pass. And if it does, they can reopen their facility with electronic gaming machines subject to all of the same rules and regulations. It also says, and let's get to this because the question was asked, does this only impact Wichita or is it statewide? These provisions are statewide, but the only vote that will be referenced is Cedric because, as Jason indicated, the other counties that are at issue, that is Wyandotte and Crawford, Northeast, Southeast, have already approved it. So the Attorney General even said that, and they're good to go. So Wichita's the only one that really matters. But if we reach into the trick bag even further, as casinos have done here in their opposition and say the opening of any of this is an expansion of gaming, that's a statewide question, and this bill does take care of that. It says it's not. It is not. Those previously approved locations remain approved, subject only to the voting requirement. So what's left? Well, what's left is if a lawsuit is going to be filed, it has protocols through this statute, as you do in many other instances where you say certain things are original actions before the Kansas Supreme Court. This would be yet another one of those. It says no cause of action against this state is ripe, meaning timely filed, until and unless the executive director of either the Racing and Gaming Commission in the case of racetracks or the Lottery Commission in the case of casinos issues a notice to all of the lottery gaming casinos saying we're about to issue a contract to a new operator. That being, let's say, Sedgwick County, because they have voted and they have approved it and a contract's been negotiated, a notice goes out. The statute says the only party then with a right of litigation to stop that is a lottery gaming facility in that geographic location. Makes sense. Why in the world would Kansas City have some objection to something going on in Wichita or Southeast Kansas? So it narrows it. It clarifies intent. Ergo, the lottery gaming facility, the casino south of Wichita, has a right to file a lawsuit in the Supreme Court within 60 days of receiving that notice, asking the Supreme Court to adjudicate that they should be entitled to repayment of their privilege fee or some portion, plus interest from the date of the notice. You may recall there's been arguments that interest should be being calculated since all the way back to when a privilege fee was paid. Why? Why? That argument has no support in the law or in the facts. Again, the bill clarifies and says, well, you're not entitled to interest until you would have some claim to repayment. Just like at the bank, You don't pay interest until you owe money. Well, you don't owe money until a notice comes out that says we're about to give this license to them, and if you claim that's a competition, you're now in the game. File your suit. If they do, it's heard in the Supreme Court. If the Supreme Court says, Mr. Beeler, your clients, whoever, you're correct, there is no violation, this is not an expansion of gaming, no right to repayment of privilege fees. It's over. It's a final decision. The state is exonerated of any liability argument. It's over. On the other hand, if the Supreme Court says, yes, we want you to pay these folks a repayment and interest, with that, the contract does not issue unless the party to receive that contract repays the privilege fee in full with the interest calculation. In other words, the state comes out of pocket zero. Question asked about repayment. Let's make clear, there are no revenues today regarding that track or any of the other tracks. They're not in operation. There are no revenues. So this is new money. There's no possible exposure to the state to come out of pocket anything. The repayment percentage of 50% is out of the state's share of the new operating revenue from that facility that was challenged. So again, you just get your money a little slower because the operator is getting repaid what they paid as a result of the Supreme Court order. And it's very important that when I've heard in several of these hearings along the way, we are saying that we, the state, repay this. Why would we do that? Well, you're not doing that out of your money. You're doing it out of new revenues that you did not have before and would never have, but for this. So, another comment made that, and this is Brendan Bussman over here, and he's an industry expert, and he's going to speak to the HHRs in more detail. But HHRs have not been determined to be slot machines. They in fact, are determined to be parimutuel wagering in most every state that the issue has been determined in. And here, this bill, as I said, state's entitled to clarify its own intent. This bill clarifies they are parimutuel wagering games to be played at racetrack facilities. So there is no question about it. It clarifies that simulcasting can go on at those facilities as well. And with regard to, I did hear a question over here by Senator Peterson, which was a good one, about problem gaming. And I would certainly recommend that whatever it should be an equating number with casinos if there's a percentage going into problem gaming. And if that's not the same, it probably should be. And I didn't have an opportunity to comment on that during the bill writing. But that was an excellent question and point. So, as I said, Mr. Bussman's going to talk about this in more detail, but I want to say HHR stands for Historical Racing Machine. When I first heard about that several years ago, I thought, well, what is that? You know, historical races, that must mean the Kentucky Derby, Belmont Stakes, etc. I was only partially right. It does mean those, but it means every other recorded race with data. That could be old Exarban, could be the old Woodlands, it could be, as I said, it could be anything, Churchill Downs, anything in Lexington. It is historical races, meaning the data is available. A bettor at that point it is not random. A slot machine is random. It has its own algorithm. You simply push a button and it's predetermined whether you win or you lose. Historical racing machines are parimutuel. They allow a bettor to look at the data. Sans, you can't see who the jockey is, you can't see the name of the horse, you can't see where the race was going to be run, which might give away things. It's all essentially a blind betting, but you do get to see which horse has which odds, and even what their historical performances are. And you bet based on that. And once you then start the race, you've entered your monetary bets, and you start the race, the machine calculates and determines how that race was actually won. So no randomness whatsoever about it. You're betting in a pool against other bettors, betting the same way. And with that, the machine shows the actual end of the race to the bettor. You can see it and see who won and what order the horses finished in. That's why it's parimutuel. That's why Kentucky has said that and Arkansas has said that, among others. So the point here, and I'll end with something I said earlier, and of course stand for your questions. This is a revenue generating bill. The state has long avoided, by not passing a bill like this, a huge opportunity for additional revenues into the general fund. That's all we're asking for. A level playing field, a recognition of protocols to protect the state from potential litigation claims that we, as I said, believe have no real factual or legal support anyway. But to someone who is fearful of that, concerned, we understand and we've addressed it. But we do want to make sure everyone understands our position that it wasn't required in the first place, but we're happy to do it and support it to be sure that our state is protected. With that, I'm going to stand for your questions, Mr. Chair, if there are any.
Okay, we'll hold questions until after Brandon Bussman.
Yes, sir.
I will do all proponents at one time. Next up, Brandon Bussman.
How's everybody doing today?
Great.
Chairman, committee members, appreciate the opportunity to be here with you today. For the record, I'm Brendan Bussman. I'm a partner and director of government affairs with Global Market Advisors. I've been involved in the gaming industry for now going on close to 18 years. I do remember when Keela passed back in '07. I, unfortunately, like today, don't get to watch those hearings like I did, but I remember this well from 15 years ago, and it's a little bit of deja vu as we sit here and continually debate this piece of legislation. But I want to specifically talk to you today about Hhrs and parimutuel wagering. And part of this is defined clear back in 1986 when parimutuel wagering was allowed in this state. It's a very acceptable form of wagering. Unfortunately, the tracks that these have been at previous to that, when they came in '86, have been shuttered. It's revenue opportunity that's sitting there, not doing anything, not generating any revenue for the state, whether that be in the 3 locations that they were outlined in Keela, off of everything. But it goes back to the fundamental thing of parimutuel wagering. And that goes to the fundamental on these machines, historic horse racing machines, that as staff introduced and as Mr. Beeler articulated as well, are based completely differently than a slot machine. Slot machine's based off of a random number generator. This is based off of races from across the world, across the United States, everything else that have already happened. These are races that, to the individual person coming in, they don't know that it. I find it a little bit humorous. I'm originally from Nebraska, so this is home sort of coming for me back here, and talking about Exarban and the heyday that it had. And I guarantee in some of those cases, when I've played Hhrs, there have been some of those races that have been from Exarban over the course of time. They maybe have been from Woodlands. But the fact of the matter is, when you go to one of these machines, you're going to make your pick based off the information available to you. You don't know what race it's from, but you do have the basic information. No different than if you'd go to a counter today if we did have racing in Kansas, or if you'd go to Churchill at Kentucky, or at Churchill Downs in Kentucky, to be able to have that same wager. No different than if I went to a simulcast facility today in Pennsylvania or everywhere else. Hhrs have become acceptable forms of entertainment, and one that is based off of parimutuel wagering in a host of states. I'm going to specifically talk a little bit about Kentucky, because they probably faced this issue the most over the last year, where they had a group come in and try to make these unconstitutional. And the legislature had to do go in and clarify a little bit of the language. And I know in my submitted testimony, I included this, but I want to specifically point out along the way how they highlighted it. Paramutual wagering, mutual systems of wagering, and mutual wagering each means any method of wagering previously or hereafter approved by a racing commission in which one or more patrons wager on a horse race or races, whether live, simulcast, or previously run. Wagers be placed on one or more wagering pools, and wagers on different races or sets of races may be pooled together. And patrons may establish odds and payouts, and winning patrons share in the amount of wagered, including or any carryover amounts. Continues on after that. The point of this is this. You are placing a wager within a pool. It's not a random number generator. It's not what you see in Vegas when you go there, or if you go up to Hollywood, which I passed when I flew into Kansas City yesterday, along the way. This is based off of parimutuel wagering. The algorithm's clearly set. That's what it's going to be based off of. These machines are no differently certified than any other machine out there, whether it be a bingo machine, an HHR, or a slot machine. And I'm going to say one of the distinctions is, if you look at GLI, which is a group that the Kansas Racing and Gaming Commission uses for their verification, slot machines are part of GLI 11, which lay out how those random number generators may be done, everything else. Paramutual wagerings in GLI 33, completely different section. It's also the section sports betting was added to along the way. And obviously I know that's an issue that's been debated in this body and within this committee for a number of years. But it's completely separate on how those are treated because it's separate wagering, separate types of wagering. And I can't say more articulately enough, when you go to one of these machines, you're going to see the finish of that race. You know, it may be, you know, say it's a quarter horse race, obviously a shorter race than if you go watch the Derby or Belmont or anything else that we're used to seeing on TV, but you're going to actually see how that race is finished, and that's determined off of the bet you wagered and what would happen as far as what you may win or lose based off of that. It's completely different than if I sit at a slot machine and just do this all day and go along the way. So with that, I look forward to your questions. I'm sure they're going to be very robust, and it's good to be back in the Midwest. So thank you very much.
Okay. Questions? Do we have any other proponents first? Nope. Okay, questions. Senator Hildebrand.
Thank you, Mr. Chairman. And my first question is for Scott Beeler.
Yes, Senator.
Thank you, Scott, for your testimony.
Yes, sir.
You made the statement early on in your testimony that the legislature writes the laws and they can change the laws.
Yes.
I agree with that 100%. Some people think it's the judicial branch or the executive branch, but I agree with it. It is the legislative branch. But to my point, there were contracts that were signed back in 15 years ago, 2007. What were those contracts based off of? Was it off the existing law, or was there something else that they based those contracts off of?
Well, parties, I feel like I'm being a judge when I say this, but parties are free to contract as they see fit. But they can't contract in any manner that is different than the law prescribes. As I indicated, I have felt strongly that the law was clear. But to those who have said we need clarity on any ambiguity, that is what the right of the legislature is, as I said, to define its own intent. So that is a definition of the law. You're defining what is already there and what you intended. So I don't see that it would have any impact in that manner.
Okay, I appreciate the answer, but it wasn't the answer I asked to my question. My question was, when the contracts were signed in 2007, what were those contracts based off of?
Well, I guess you'd have to ask those. I'm not a party to any of those contracts. What they were based off of, they're based off of their negotiated positions, that being the Lottery Gaming Commission and whoever the applicant would have been.
And the KELA Act? Would it have been based off of the KELA Act?
Well, they're based, again, off their independent allegations. To the extent they refer to KELA, then yes.
Okay. So if I sign a contract with somebody based off of what I know the understanding of KELA is. And then does the person, one single party, get to change the contract, definitions in the contract because they want to clarify it?
Yes, I think in the sense of a legislature, no legislature is bound by the acts of a prior legislature. That's again a statement of the law in Kansas. You cannot bind your future, those who sit in your seats. So because everybody has the right on a yearly basis to revisit the law.
I don't disagree with that. So all contracts signed by the legislature then can be null and void after each election cycle.
They can be revisited. Yes, they can. And are.
Okay, further questions? Senator Fasco.
Thank you, Mr. Chairman. Thank you, Scott.
Yes.
For being here. So I was around here in '07 and '08, and over in the South Central Kansas area, we have the Kansas Star Casino.
Yes.
And at that time, there were provisions put in law regarding certain monies that would go to the city or to put into education or to problem gaming. And I've been out there a couple of times just to watch boxing, Mr. Chairman.
Oh.
Yeah. And so, but if you can, for those listening in, share the major difference of that casino like Kansas Star Casino versus the reopening of the Wichita Greyhound Park.
The major difference?
Yeah.
In the sense of what one can do and the other can't?
Yeah.
Okay.
Yeah,
Well,
thank you.
certainly when for anyone who has happened to go to Vegas or any other full-blown casino operation, first and foremost, table games. The casinos are the only ones allowed to have those. Now, I'm excluding Indian casino, the Native American facilities across the state. But as opposed to racetracks, they cannot have those. Racetracks are limited to Paramutual together with electronic gaming machines. That's the major difference in terms of their operation. Secondarily, an enormous difference is how many machines they can have. The entire state of Kansas is limited, and I don't have that right on the tip of my tongue, but I believe in terms of the 3 racetracks, they'd be limited to 2,500 machines. I'm off by a little. You could have that many machines in the Kansas Star. And so it will be much larger than Wichita Greyhound Park in terms of EGMs. Same is true in Kansas City if there was a race facility there competing with Hollywood. Same as in Southeast Kansas. And of course, we don't have a racetrack in the Southwest. So many more machines means much more revenue. So bottom line, it's a big dog versus little dog concept in terms of the differentiation.
Thank you. Senator Longbine.
Thank you, Mr. Chairman. Mr. Beeler, thank you for being here today.
Yes, sir.
One of the points that you made in your testimony that I heard is that this is new money, new opportunities.
Yes.
So this is a whole new customer that goes to this type of facility, or are you asking the committee to believe that current customers of casinos would be a different clientele than this?
That is
Some clarification.
I very much appreciate you bringing that up. In prior meetings, experts have come in to testify that both things you just said are true. First of all, Paramutual has its own base set of customers that want to go bet on simulcast races, that want to be involved on the racing side in some way, and yearn to do so, and won't go play table games. That's just their makeup. It's not what they want to do. There is plenty of data to support that. Secondarily, the adage of the high tide raising all boats. having casinos and a racetrack operation in the same geographic zone, as I indicated earlier, was intentional by the legislature back all the way beginning in '86, then working up to 2007 and ultimately 2010. Why? Because gamblers are all going to go to that general location. They then might not be doing well that evening early and say, well, let's go try this or that. So there is the spillover in that way as well, that folks want choice. I think we've all heard that, and in today's world, that's more true than ever. They want a choice. But on top of it, as I said, you have an entirely new clientele available that wants to go to that racetrack. And as I said, forgive me if I've forgotten that you heard that before, but if you weren't here at that time, we did present that information.
I do not doubt that there are new clients, but I also realize that there's likely to be some crossover.
Yeah, both are true.
Taking it out of one hand, putting it in the other, whatever that percentage is not necessarily new money, it's exchanging money. And so to say that it's all new money, that's why I asked the question.
I understand.
My second question is in your legislation, is there a limit on the number of facilities that could be opened in the state?
Yes. 3.
And so no new locations, no satellite locations?
No.
3 existing?
No change whatsoever to the geographic.
One gaming zone for three zones?
Absolutely correct.
No satellites?
No satellites.
Thank you, Mr. Chairman.
Senator Straub.
Thank you, Mr. Chairman. I assume prior to the closing of the racetrack in Wichita that they were paying property taxes. Do you know what the property taxes were prior to and after closing?
Happy to provide that, Senator. I don't know that offhand. We'll make sure you get that.
Thank you. I'm just thinking about this in relation to Senate Bill 347 that the legislature I believe there's a 50% property tax credit as part of that bill, if I'm not mistaken. And it would seem to me that it would be somewhat hypocritic if we were giving tax credits for new business and those type of things to an unknown company and absolutely unknown what they do and what kind of activities they support, but yet hindering economic development in a community that we absolutely know what the activity is that's going on there. So just have some questions in relation to creating revenue and also jobs. I believe when that racetrack closed that it caused a loss of maybe 400 jobs or so. I was trying to do a little bit of research because I wasn't here in 2007. So just want to make sure we have all the pieces here. Thank you.
They were not all FTEs, but 400 total jobs.
Thank you.
Senator Longbine.
Thank you, Mr. Chairman. Mr. Beeler, I'm sorry, I forgot one of my questions.
Not a problem.
I've got a 7-page fiscal note here that talks more about costs than it does revenue. Do you have an estimate of what kind of revenue this would generate for the game, for the operator and or the state based on the tax rate so that we can calculate approximately how much revenue this will bring in?
Once again, I do not have that information with me today. I would certainly be willing to ask for it and provide it to you.
If you could just provide that to Michael, he'll distribute it to the committee. Maybe Andrew, if you wouldn't mind looking at what the other states that have these machines, how they do, and then look at all 3 racetracks, what property tax they paid.
That'd be one of the real driving points of that budgeted information is how they do in these other states with that.
Certainly, and I agree with that. I'm sure that your client or someone has done a performance.
They have.
Make a business case for this, and
They have.
some kind of estimate of what kind of revenue this may generate.
Yes, sir.
Thank you.
Okay. Any further questions? Not seeing any. We'll go ahead and move on to the opponents. Thank you. Whitney Dameron.
Thank you, Mr. Chairman, members of the committee. Whitney Dameron here. Again, on behalf of Kansas Entertainment. Kansas Entertainment owns Hollywood Casino at Kansas Speedway. It's a 50-50 partnership between Penn National Gaming and Kansas Independent or International Speedway Corporation. We've been here before. We've talked about similar bills. This one has a different twist added into it. It attempts to redefine parimutuel racing as historic horse racing. I think if you want to kind of get your arms wrapped around that, either look sideways or stand on its head, because this is nothing like what the Kansas Legislature envisioned when they passed KELA back in 2007. It was designed to support the parimutuel industry in the state of Kansas. And so now we're at a point where we have legislation in front of us that would allow us to consider some kind of a legal fiction that old horse races can be computerized and run through a machine that looks like a slot machine. If you Google historic horse racing, they look like slot machines. They operate very much like slot machines. And we're going to accept that in the Kansas Legislature and state of Kansas, that is parimutuel racing. It's not doing anything to help the breed groups that the track owners committed to help when they supported Senate Bill 66 back in 2007. You talk about what might have closed the tracks. Well, by and large, the tracks didn't open. They lost the vote in Cedric County. They never opened in Wyandotte County. And in southeast Kansas, I think they ran 20 days and shut down. So the industry pushing this legislation has failed the breed groups in Kansas time and time again. And the only thing they want to do with this kind of a bill is to run in some potential simulcast races from races outside the state of Kansas and use that to essentially touch home plate to be able to offer this historic horse racing. Yes, historic horse racing has been legalized and authorized in the state of Kentucky. It actually was declared illegal several times by the Kentucky Supreme Court until the legislature finally passed a bill allowing it to happen. As one might suspect, the horse industry is pretty strong in the state of Kentucky. They have a big race there at least once a year that a lot of people watch. 5 days ago, the Oregon Attorney General, where a similar battle is going on, took a look at this. He declared it illegal in the state of Oregon. I just want to quote from that. After reviewing the features and design of historic horse racing proposed by the racing group, we, the Attorney General, determined that machines are games of chance that do not afford players any meaningful opportunity to exercise skill. As a result, they conclude they are lotteries. Lotteries are constitutionally prohibited in Oregon unless they are run by the state lottery. Thus, HHRs cannot be authorized by their racing commission. Sounds kind of like Kansas to me. Looks like a duck, walks like a duck, quacks like a duck, it's a duck. I don't think the fact that historic horse racing has been deemed parimutuel racing in other states is settled law. So I leave that to you. I think there are also other problems with the bill. The proponents don't come out and say it, but what they're suggesting is state of Kansas, the legislature can abrogate contracts. That's the issue that I believe Senator Longbein, Senator Hildebrand were talking about. Contracts were entered into, arm's length transactions. There were substantial penalties put into law in case the state of Kansas changed its mind and decided they did not want to limit gaming as it was authorized in Senate Bill 66 in 2007. Those penalties accrue each and every day from the privilege fees that were paid by the casino operators and an interest rate of 10% per annum. That bill is, I believe another conferee may get into that, but that bill is somewhere around $180 million today if those contracts are abrogated. The legislation before you tries to suggest that the only casino that would have an action against the state is the one where they would choose to place this facility and have a revote, Cedric County, the South Central Zone. Again, abrogation of contracts, all casinos entered into state contracts with the state of Kansas for the limitation of gaming. There's a question raised about the reimbursement from the state of Kansas back to the facility owner. in Wichita, should they be allowed to have a revote and a penalty incurred? I think the way the bill reads is not less than 50% of those state revenues would go to the owner. It's not up to 50% or under 50%. Finally, I would say you read the bill. Also, it's not a Cedric County bill. The way this bill is written, it would authorize a slot parlor in Wyandotte County where they don't even have a track anymore. So that is clearly outside of the scope and the intent of the legislature back in 2007. You could have a freestanding slot parlor that's going to wheel in a couple thousand historic horse racing machines and call it Paramutual. Similar in southeast Kansas. At least they do have a track down there, but it operated, I think, 20 days under Keela. With that, Mr. Chairman, again, we're opposed to the bill. We think there are significant financial penalties that would incur to the state of Kansas. Questionable whether the state would be reimbursed at the level being provided for under this bill. And the bill also attempts to limit the financial penalty to only privilege fees and interest and not other damages, which clearly the contracts allow for the track or the casino owners to pursue other damages as well. So we think the bill, like all those that have come before it, have problems. Thank you, Mr. Chairman.
Thank you. Mike O'Neill.
Thank you, Mr. Chairman. My wife Trish and I have the privilege of representing the Kansas Greyhound Association. And as the bill was originally introduced, we had major concerns with it that we now understand from visiting with the revisor were unintentional, and it appears they were unintentional on the part of the parties who introduced the legislation. We don't have any particular problem with the business model that we have no opinion one way or another, but there was language in the bill that Jason has indicated was unintentional. We just ask that you approve the technical amendment that would basically not prevent us from operating. And the other favor that we would ask members is, you may hear a lot of things about greyhounds and greyhound racing. Don't make any uninformed judgments based on outrageous claims that can't be verified. If you have questions, the welcome mat is open to any of our facilities in Kansas. Trish and I have been out to the facilities. It's one of the best experiences that we have had. These are incredible four-legged, sweet athletes. And just don't make any uninformed judgments until you have a chance to learn more about the industry. I'm really here to introduce Jim Garland, the Executive Director of the National Greyhound Association. You also have written testimony from Michael Strickland, who's the President of the Kansas Greyhound Association, three-generation breeder and trainer of greyhounds. We don't want to belabor things because we understand that the intent was not to affect us, but if you'll indulge him, he's traveled from Abilene to be here. Thank you.
So if, with that amendment, you would probably be a neutral?
We would be neutral if that amendment were passed, yes.
I was asked that question. Okay. Jim Garland?
Thank you, Mr. Chairman, members of the committee. Like I said before, the amendment was talked about. My testimony is probably much longer and much more temperamental, but with that news being shared, I'm just glad to hear that. While we're still disappointed that Mr. Ruffin is choosing to go this course without having to hold racing and trying to make it that way, in South Central Kansas and the Wyandotte County. We really don't have any opposition to it. We just want to make sure that the greyhound racing is alive and well, because there are people in the state now actively pursuing racing again, and we'd hate to see it go away. And I just pointed in my written testimony to the popularity of the racing right now. In West Virginia, over the last 2 years, wagering on racing in that state has increased 187%. So it's not a dying sport. There's a lot of interest to it, and that's why in the Ruffin bill they want to have simulcasting as well, because it's very lucrative. So while we don't oppose it as it is now, we just want to make sure that the greyhound racing is kept alive, because it is a viable option, and we want other people to have the opportunity, even though Mr. Ruffin chooses not to have that. Thank you.
I'm sorry, Midge Granstead, virtual. Okay, do we have someone on there? Who? Okay, well, we'll move on to Kevin Fowler.
Thank you, Mr. Chairman, members of the committee. My name is Kevin Fowler. I'm with a Topeka law firm called Frieden and Forbes, and I am appearing today on behalf of the three managers of the state-owned and operated casinos in Dodge City, which is Boot Hill Casino, the casino in Mulvane, which is Kansas Star Casino, and the casino in Pittsburgh, which is Kansas Crossing. And I'm appearing on behalf of these casino managers in opposition to Senate Bill 404. Our opposition to the bill is very simple. I've submitted written testimony. I'm not going to read from it, but I would direct your attention to it because it kind of underscores the central point, and that is this bill, if enacted into law, will not only abrogate commitments made to the casino managers in this state under the Kansas Expanded Lottery Act, which was passed in 2007. There is nothing unclear about what that act says, what it authorized. In fact, following the enactment of KELA, based on the KELA framework, the Kansas Lottery went through the arduous process of soliciting bids and negotiating contracts with several private business entities, which then competed before the Lottery Review Board for the award of the contracts. It was a competitive bidding process under the KELA framework. The casino managers currently in place entered into contracts with the state pursuant to KELA, which this bill proposes to abrogate. And people can talk about the intent of the legislature all day long because that is key. The intent of the legislature in 2007, as expressed in the plain language of the Kansas Expanded Lottery Act, is the only intent that matters with respect to the contracts the state has entered into. And by the way, I'm not going to pound the lectern, even though I may be passionate about my views on this issue. And this bill proposes to abrogate those contracts based upon the statutory framework that Kansas enacted 15 years ago. And now the bill proposes to pull the rug out from under the casino managers who have invested $1 billion in the state's economy. And what is that going to do to the business investment climate in Kansas? Try encouraging businesses to come to Kansas if they know that several years down the road, statutory commitments can be changed at will. Now, I've attached to my testimony the opinion of Derek Schmidt, the Kansas Attorney General, that he issued in connection with a similar bill that would just authorize a revote in Sedgwick County. And this was an opinion issued 6 years ago in 2016. And the Attorney General concluded that the state will be exposed to significant liability in the event that a revote is authorized in Sedgwick County affecting only the Kansas Star. This bill does more than that, which I will address in just a second. And the reason it's a problem is because the United States Constitution specifically says that no state shall pass any law impairing the obligation of contracts. This is a federal constitutional issue, and Derek Schmidt relied upon the Kansas Supreme Court's application of that federal constitutional provision to state, and this is important, it's on page 3 of my testimony, that where a valid contract with the state has been entered into in pursuance of a legislative enactment, like KELA, a subsequent legislature cannot enact a law which provides for an abrogation of the contract. That is black letter law in the United States, and that is why a significant portion of the first 7 pages of this bill recognize we're going to be sued. Let's see what we can do to minimize the likelihood we're going to have substantial liability. That should raise a red flag for everyone. This isn't run-of-the-mill legislation. This is a bill that has almost the first 7 pages devoted to trying to limit the state's liability, and they do it in ways that are un-American. They deny my client's right of access to the courts. They eliminate existing remedies under current contracts. You can't get injunctive relief, which is available today under this bill. You can't even get a jury trial. Ladies and gentlemen, this bill is something this committee should reject. Now, there was discussion about this is just pari-mutuel under the old Senate Bill 66. It is not. This bill does not require live racing. When KELA was enacted in 2007, there were existing racetracks. And in the event they had, in the case of Greyhounds, 360 live racing days, they could have electronic gaming machines. 360 live racing days a year, you can have electronic gaming machines. This eliminates any live racing requirement. In the case of Wyandotte County, they needed to also have 60 days of horse racing a year in order to have electronic gaming machines. That requirement is eliminated from this bill as well. This is a slot parlor bill that not only affects 3 of the gaming zones, it affects 3 other counties because these historic horse racing's former Paramutual licensee location. There are 3 of those currently outside of the 4 gaming zones. So this isn't limited to 3 counties. It's actually 6 counties. Harper, Rooks, and Greenwood counties also are authorized to have a vote to authorize these historic horse racing games because they are former Paramutual licensee locations. And these are slot machines, make no mistake. The Wyoming Supreme Court concluded in 2006, we are not dealing with a new technology here. We are dealing with a slot machine that attempts to mimic traditional pari-mutuel wagering. Although it may be a good try, we are not so easily beguiled. And I would leave you with those words from the Wyoming Supreme Court. This is a bad bill. It's going to subject the state to hundreds of millions, if not $1 billion in liability, much of which isn't even covered. The only thing that's covered in terms of the facility operators and state reimbursement are the privilege fees. It doesn't cover consequential damages, which could be in the hundreds of millions. And as a consequence, this is a bill that should be a non-starter, and we would urge that you reject it. Thank you.
Thank you. We got one more opponent, Terry Hhrs.
Good morning, Mr. Chairman and members of the committee. I am Terry Humphrey, and I'm appearing today on behalf of Stray Dog Policy. We're an organization that advocates for pet protection. And what I would like to share with you is we have no position on gambling, as you can imagine, unless it impacts animals, pet animals, dogs, and in this case, greyhound racing. We recognize and appreciate the fact that Senate Bill 404 decouples greyhound racing from the Kansas Expanded Lottery Act so that live greyhound racing is no longer required at a racetrack facility to offer slots. We are aware of that. Nevertheless, we oppose Senate Bill 404 because it incentivizes the return of simulcast greyhound races by eliminating the live greyhound racing requirement, therefore making it easier to obtain a simulcast license. This expands exponentially the number of licenses that may be issued. Greyhound racing has been rejected by your constituents because it is inhumane and it does not align with Kansas values. It also is inconsistent with Kansas efforts to be a leader in animal health. In closing, we oppose Senate Bill 404 as written. If the committee wishes to advance this bill, we respectfully request that you amend Senate Bill 404 to prohibit simulcast Greyhound racing. And I will stand for any questions that you may have.
Okay, thank you. Questions? Okay, I think everybody's done a good job. No questions. So we'll go ahead and close the hearing on Senate Bill 404, and we will move to Senate Bill 391. Jason, can you give us, well, at least this looks like a small bill. We'll see.
Thank you, Mr. Chairman, members of the committee. Senate Bill 391 is a short bill directing the Secretary of State to develop a ballot system so that the number of years of service in office for an incumbent candidate running for re-election would be specified next to that candidate's name on the ballot. So, for instance, if the candidate had been in office already 8 years and was running for re-election, then that 8 years of service notation would be indicated next to the candidate's name on the ballot. There are statutes already dictating ballot presentation and names presented on the ballots, party affiliations, and so this requirement would obviously need to be worked in with those existing requirements for how ballots are presented to the voters, but that would be handled by the Secretary of State through probably the rules and regs process. The bill will go into effect on July 1st of this year. I'd be happy to answer any questions.
Questions? Not seeing any? Okay, first up, we'll open the hearing on 391. Senator Hildebrand.
Thank you, Mr. Chairman. You guys have my written testimony, and the only thing I would say is it's a great bill, and I'm looking forward to you guys passing it. Just kidding. No, it's a pretty simple bill. It's one paragraph, two if you count section 2, but basically all this will do is just allow voters, whenever they go to vote, to see how many years that person they're voting for has served in that specific office. This will allow the voter that information. Some voters want experience, some voters want term limits, and this will provide them that information.
Okay, questions? Senator Reichman.
Thank you, Mr. Chair. I never heard anything like this before. Has any other state have this kind of policy? Thank you.
Go ahead.
Not that I'm aware of. As far as I know, this is a new endeavor.
Senator Straub.
Thank you, Mr. Chairman. Full transparency, I really like this idea, but I do have a question. If you could specify, does it include, so say someone was in the Senate for 4 years, was in the House for 2 years, then back in the Senate for 4 years, is it cumulative or is it consecutive?
So the way this is written, and Jason can correct me if I am misinterpreting it, but it would be years of service in that office. So it would be a cumulative.
Yeah, I don't think you would put, if you're running for the Senate, I don't think you would have on there, I'll serve 6 years in the House and 10 years in the Senate, or 12, just say your Senate years. That's how I'd read it. Go ahead, Senator Straub.
Thank you, Mr. Chairman, because oftentimes when considering term limits could be a number of consecutive terms, but no max number of years served. So you can get into different issues if you were talking about term limits, but there are a few people that bounce back and forth between offices so anyway, but otherwise I absolutely like this. Thank you.
Senator Senator Fascadeau.
Thank you, Mr. Chairman. Surprisingly, I don't really have a major issue with it, just on the same lines of Senator Straub. So a lot of people will say, I've served two terms in the legislature, and some will just say the total amount of years. So how would you address that again?
The bill is years. It's not terms, it's years.
Okay. Further questions? Senator Hllsher.
Thank you, Mr. Chair. I don't see it in here, but is it all offices, even like water board, city council, that type of thing? Did you say that already, or did I miss that?
You said water board there.
Oh, I'm sorry.
So it does not specify one specific office, so the way it reads, and again, Jason can correct me if I'm wrong, it would be anybody running for office in any could be a township board or water board or Senate or U.S. Congress.
Okay, thank you for clarification.
Some people look at it as a negative. I don't always. I think sometimes there's wisdom in people. Senator Straub.
Thank you, Mr. Chairman. So just to clarify, it's the number of years that would appear next to your name are only for the office that you are running for. It's not cumulative number of years of all elected offices, right?
That is correct. Just for
Thank you.
years of service in that particular office you're running for.
I guess if that's the case, I would be in my working on 43rd year of office. Is that it? Any further questions? Okay. We have 3 written proponents and then 1 written opponent. Oh, 3, I guess, written opponents. Is there anybody here that wants to be an opponent? Okay, we got a neutral, Rick Pipo. I'm always saying it wrong. Go ahead. Yeah, Pifo. Yep, go ahead. Oh, yep, we do have the Secretary of State's office if he wants.
Yeah.
I'll let you go first.
Okay. My name is Rick Pifo. I'm the Harvey County Clerk and Chair of the Elections Committee for the Kansas County Clerks and Elections Officials Association, shortened to KCCEOA. We're testifying neutral on this. My only real concerns are the space on the ballot is very limited. There's not much real estate there. I put a little example of one race. So that is somewhat of a concern. I'm sure we can probably figure out a way, or with the rules and regulations from Secretary of State, we'd figure out a way to do it. My other concern is collecting the information. Would we ask the candidates to tell us how many years they've been in office? Would we need to maintain a database so that we can verify that if you say you've been in 2 years, but you've really been in 4 or 6 or whatever? Currently, I have township officers who have been in office for 20-some years. They don't always know. They'll say, when was I first elected? So I go back through all the books and say, okay, here's the first time you were elected or appointed. And I guess it doesn't really say, I know we put the number of years for the incumbent, but what do we do for all the challengers? Would you just put a 0, or they just don't get anything? It's just a question. So there's just a few little technical issues that we're concerned about, making sure that we can do the job that you're wanting us to do. Thank you. I'll stand for questions.
Okay, we'll hold questions to the end. Clay Barker, Secretary of State Office.
Thank you, Mr. Chair. Good to be back again. We're neutral on the bill. We understand the intent completely, and these are just 3 points to keep in mind for working the bill. One, like Mr. Pifo said, since ballots can't get wider, if you put more information on them, they get longer, and it could kick it over to an extra page, which may cost a little more. The more information you put on a ballot, it's just inevitable that someone will make mistakes. If you remember Senator Billinger, there was Ellis County. They described his office wrong. It happened with Senator Bowers, too, in one county, but she had no opponent, so nobody noticed. And there could be a little mistake in here. I don't think it would have any effect on election, but an unhappy candidate could complain. And we were just brainstorming in the office about details, and we're we can figure this out, but we probably take input from the committee and then the county and the public. Would it be, for instance, if one of you was running for reelection after one term, would it say 4 years, meaning if I am reelected, I will have served 4 years, or would it say 3 years, 7 months for the primary and 3 years, 10 months for the general? We can handle any of that, but we take input on those kind of decisions. You already answered one, that it would be for all candidates, and we weren't sure about judicial retention elections, if they're considered. I don't think they'd be considered a candidate, but we'd probably need a little guidance on that. And that would be it,
Okay.
Mr. Chairman. Again, we're perfectly, if that's what the committee wants, we can get it done. We just may have some detailed questions, which we can figure out, but we'd probably just ask you all for some guidance as we go through it.
Sure.
What your intent was.
Questions? Senator Hildebrand.
Thank you, Mr. Chairman, and my question is for Frank Pifo. On your example, it was pretty small, and
Yeah.
you said that's the space that you have. So my question was, how do you put so much wording on a constitutional amendment in a ballot?
I'm just saying, overall, the space on a ballot is limited, as Mr. Barker said. We can't make it wider, but we can make it longer. Sometimes a constitutional amendment may fill up the whole back of the ballot. So if you start expanding all of the other races before that, then it becomes less likely that you can make it all fit without making the type so small that it's, but there's regulations on the size of the type.
Okay, further.
Just
Go
a
ahead.
follow-up, if I could. It makes, I apologize, it makes no sense, because you can put 5 pages of a constitutional amendment, and you're not bound or restricted by space, but you're saying by adding years of service, you're going to be restricting your
No,
space.
we can't. I mean, you could have a 5-sheet ballot. We try to make sure that ballots are not more than 1 sheet of paper. And to do that, we expand the length of the paper. So really long constitutional amendments are a problem, and/or adding more and more races to the ballot potentially would cause multi-sheet ballots, which there's other issues with getting those tabulated and everything.
Sure. Thank you for that clarification.
Go ahead, Senator Fresco.
Thank you. My question is for Clay. Thank you. So when there is a question on a ballot, so who determines the length, the wording of the ballot? Is it us, the legislators, or your Secretary of State's office?
Senator, for a constitutional amendment, it's the legislature decides that. For local issues, it's the county, and the Secretary of State has some input on the ballot style.
So, Mr. Chairman, so when it was the vote for the revote for Cedric County, or the initial question of Greyhound Park, who decided the length of that question? Just going with Senator Hildebrand's, I know we have voter fatigue. I know we have the additional pages and all of that, but who determines the amount of words that can be on a question? Us,
Senator,
the county, or you?
I'm not sure. I understand the question. I just don't know on something like, I don't know if it's in the statute that's passed or.
I think Jason's got an answer to our question.
That particular question would have been the Board of County Commissioners, because they would have approved the resolution submitting the question to the voters of Cedric County. So they would have been the body finalizing the form of the question.
And Mr. Chair, if I could add one more thing that was just texted to me. The effective date of this bill would probably overlap with the beginning of at least the primary election, because the ballots have to be ordered. I mean, we know who the candidates are 1 June, and they immediately order ballots.
Yeah, if this bill moves forward, we're going to have a lot of work on it. Senator Hhrs.
Thank you, Mr. Chair. That was actually my question, as far as the timing of the bill and how much workload it would create to be able to do what this is specifying as far as adding that information.
The concern was the state may not be able to pull it off for the primary in 2022, but the general they should be able to, if that's a concern.
Senator Reichman.
Thank you very much, Mr. Chair. I think I understand the intent of the bill. I'm not a proponent of term limits. I do believe this could be a problem with adding on other things. That's why you have elections. People should be informed. I think this is an unnecessary bill. For people for limited government, you're adding more on it, and I'm opposed to this bill. And I'm not asking you for a question. I'm just running my mouth. Thank you.
Senator Straub.
Thank you, Mr. Chairman. I really do still support this. I would only ask that we specify in the language of the bill that it not just be a number, that it clearly says incumbent with whatever the number is, years of service or whatnot. So it doesn't appear, because when they mentioned a number and then, if the I don't want it to look like it's a rating or something else, because some of those years of service can get pretty high, and you don't know what kind of, you wouldn't know, maybe the voter wouldn't understand what it meant.
And we were thinking what the introductory wording would be to indicate what the number stood for.
To do it, we got several things that we need to fix and get them right. We don't want to screw up the next election by putting something on there that, nobody understands. So I think we'll think about this bill. Do we got enough time to work one quick thing? Because I'm sure there's one person that's sitting in here at least that might be wondering if we're going to work this. 376. This is the bill dealing with the MIH. And there's one amendment that we put on there, and I don't propose to take it out of the bill or anything like that, so. 376. Basically, if you remember the one we had yesterday, we had the portion of counties with 8,000 or less. Well, I did the same thing in this bill. I took counties with 8,000 or less would target 3 million, and counties 25 million or less would target another 3 million. So that's the balloon I'm wanting to put on that bill, and I'll make that motion if there's a second. Do I have a second? Senator Hildebrand, second. Oh, go ahead. We got a motion and a second, so go ahead.
Thank you, Mr. Chairman. Sorry to interrupt. I haven't had a chance to go back through this again, but is this the one? Because there was a couple similar bills that we
passed one out
Okay.
yesterday that was the tax credit. This is the MIH grants. And
so these would be grants to housing,
for housing,
construction, developers. This is not a grant specifically to the homeowner or the renter?
This would be to, there'd be a development or approved development. The grants are normally small portion. You want to speak to it? I'll let you.
Mr. Chairman, the provision being amended is Section 3 of the bill, and these are grants by the Kansas Housing Resources Corporation out of the State Housing Trust Fund to cities and counties for infrastructure or housing development in rural areas. And so under the bill, there is an expansion of both the amount of monies being transferred to the State Housing Trust Fund, and then also an allocation of 25% of those monies to cities or counties with a population of 60,000 or more, with the other 75% being retained for the current statutory use for rural area housing development. And then the balloon on page 4 would allocate $3 million of that transfer money to counties with a population of 8,000 or less, and $3 million to counties with a population of between 8,000 and 25,000.
Kind of what we were talking about. Yep, go ahead.
Sorry to ask all these questions, but I think we kind of went through these pretty quickly the other day, and I just want to make sure. So if the grants are provided to the cities and counties, how exactly does that money get back to the homeowner or the person who's going to purchase the home or rent the apartment? Is the grant then transferred from the city or county to the developer or the construction company? Or is it directly transferred from the city or county to the renter or homeowner? Sorry.
I believe how they work is they would go to the developer. It's part of the development cost. I can get you, we can hold off. You know what, we're out of time anyway. You know what I'm going to do? I'm going to hold off tomorrow, and if we got 2 bills, I believe, up tomorrow. And if we don't get done tomorrow, we'll just come back in after session and clear out the bills we got in there. And, well, after session, so sometime after. I'll look and see, but sometime tomorrow afternoon, just expect we're going to come back in and work them bills, because I'd like to get a few of them to the floor for turnaround, so we have plenty of work to do and keep our calendars clean. Committee, we're adjourned.